Well, here we are in Oxford. It's a great pleasure and a great privilege to me to be back here. I think I was last here when I too was getting some of those wonderful Oxford gloves. I have to assure Mr. Justice Kavanagh and the attorney that I never got to wear them. They're far too pretty to wear, and you must keep them, of course, very safe for your grandchildren. But of course, there's another thing about being here in Oxford. It's the home of scholarship and of the freedom of thought and freedom of expression which are essential both to scholarship and the search for truth. Both of these are protected by the European Convention on Human Rights and, for the time being at least, by the Human Rights Act 1998. But so too is freedom of religion. So what are we to do if those two freedoms seem to be in conflict? I have a particular interest in this subject because one of the first projects to hit my desk when I arrived at the Law Commission in 1984 was blasphemy. As part of its grand project to codify the criminal law, the Commission was investigating the few remaining offences defined not by statute but by the common law. These included blasphemy and blasphemous libel. Everyone thought that they were obsolete until 1976, when Mary Whitehouse brought a private prosecution against Gay News and its editor Dennis Lemon for publishing a poem written by Professor James Kirkup entitled "The Love That Dares to Speak Its Name." It's not a very good poem, but it packs a certain punch. It tells in graphic detail of the passionate love felt for Christ by the Roman centurion who lifted him down from the cross after his crucifixion. It also claims that the risen Christ had appeared first to the centurion on the third day. So, it was not questioning the divinity of Christ or his resurrection from the dead, the central tenets of the Christian faith. Far from it. But it was deeply shocking to many Christians, partly, no doubt, because of its description of homosexual acts, and partly because it alleged that Christ himself was gay. The trial judge directed the jury that the prosecution didn't have to prove that the publishers or editor intended to attack the Christian religion, or to insult or outrage Christian sympathizers or believers, or to provoke a breach of the peace. It was enough if the poem vilified Christ in his life and crucifixion, and the defendants intended to publish it. The jury convicted both defendants by a majority of 10-2. The publishers were fined £1,000, and the editor was not only fined £500, but given a sentence of 9 months imprisonment, suspended for 18 months. The conviction, though not the prison sentence, was upheld in both the Court of Appeal and the House of Lords, which was then the highest court in the land, albeit by only 3-2 in the Lords. Lord Scarman, in the majority, thought that the law did not go far enough. Quote, "In an increasingly plural society such as that of modern Britain, it is necessary not only to respect the differing religious beliefs, feelings and practices of all, but also to protect them from scurrility, vilification, ridicule and contempt." The Law Commission's first thoughts, in a consultation paper published in 1981, were that the common law offences must be abolished. And in today's plural society, any replacement would have to apply to all religions and not just Christianity. The Commissioners reached the provisional conclusion that the offences should be abolished without replacement. This provoked a huge response. 1,800 organisations, groups and individuals, and more than 175 petitions with a total of nearly 12,000 signatures. So, bowing to this pressure, the Commissioners decided to recommend a replacement offence of injuring religious feelings. Any religious feelings without defining what a religion was. They were going to leave that tasty morsel to the judges, Mr. Justice Kavanagh. So there we are. It was customary then for Law Commission reports to be accompanied by a draft bill to give effect to their recommendations. But the parliamentary drafters were not keen on this proposal, and so were taking their time. And that was how things stood in May 1984, when I, along with Professor Julian Farrand, a lifelong atheist, joined the Commission. We both voiced our opposition to the proposal, so it was decided to wait until another new member of the Commission, Trevor Aldridge, joined later that year. He quickly sided with Professor Farrand and me. So what had been a unanimous report in favour of a replacement offence became a 3-2 report in favour of abolition without replacement. Of course, nothing was ever going to come of it. What government was going to risk alienating its supporters, both in and out of Parliament, by trying to abolish blasphemy? But never say never in law reform. What were the reasons for having such offences? The Commission could think of 4, and there were objections to each. The first was the protection of religion and religious beliefs. The problem is that this can only apply to the protection of the god or gods of one faith. It's quite rational for a state which has a state religion to protect that religion, whether Judaism in Israel or Islam in Bangladesh or the Church of England in England. But no one, including the Church of England, thought that it was any longer justifiable to protect just one faith. Instead, we assert the right of everyone to hold and manifest their own religion or belief, including the belief that there is no God. So that wouldn't do. So the second reason was the protection of society. Attacking religion, it was said by the Times, amounts to an attack upon the fundamental decencies and mutual respect on which society operates and could damage the stability of a community. The problem with this argument is that everyone agreed that no harm is done by rational and sober, as distinct from scurrilous or abusive treatment of religious matters. Yet we all know that it's quite possible for a work of serious literature to induce outrage among some people. We might think of Salman Rushdie and the Satanic Verses. Indeed, rational argument may be much more persuasive than scurrilous abuse, and thus induce much stronger feelings in response. We all know what it's like to have a really good argument put against us, don't we? It makes us really cross, and we can't think what the answer to it is. And as the leading academic criminal lawyer of the day, Professor J.C. Smith, pointed out, some religious beliefs deserve to be condemned. Should it not, he said, be possible to attack in the strongest possible terms religious beliefs that adulterers should be stoned to death and that thieves should have the offending hand lopped off, however offensive that might be to the holders of that belief? So that wouldn't do either. A third reason was the protection of religious feelings. In the working paper, the Commission had thought this the most persuasive argument, although by no means decisive. But the law doesn't generally impose criminal penalties for injuring a person's feelings. So the argument must depend upon the notion that religious feelings are different from other kinds of feelings and worthy of special respect. Now, of course, many religious believers do indeed believe this. The working paper had suggested that such feelings might be different because of the special reverence felt for what is deemed sacred. But is such reverence special, either in its degree or in its quality? Many people feel equally strongly about all sorts of things, including the lack of religion, but they're not protected from being upset. And is there any real difference between reverence for a deity and other kinds of reverence? For example, for your country, your monarch, your national flag, your football team, your choir, or your parents. Contempt for any of these may be thought just as deplorable as contempt for a deity. But we can't extend the criminal law to protect all these sorts of feelings. So that won't do either. And the final reason discussed was the protection of public order. We all know that expressing beliefs about religion, for or against, general or particular, can arouse strong feelings which can escalate into public disorder and worse. Only last September, hundreds of young men fought one another and the police over 2 nights in Leicester, all said to be sparked by the anti-Islamic policies of the BJP in India. But we have the Public Law Order Act to deal with that. It penalises all sorts of threatening, abusive or insulting words or behaviour, and writing signs or other visual representations which are likely to cause harassment, alarm, or distress in public. Is there any evidence that purely private attacks upon religion are likely to lead to public disorder? So, in the end, that is why the majority of the Commission concluded that none of these reasons were sufficient justification for the serious invasion of freedom of speech which an offence of injuring religious feelings would involve. Curiously, the European Court of Human Rights in Strasbourg appears to take a different view. It thought that the protection of religious feelings was a sufficient justification for the conviction of the editor and publisher of Gay News, and it's reached similar conclusions in more recent cases. Now, to my mind, the Law Commission report drew an important distinction between attacks upon a religion and attacks upon the people who hold its beliefs. The offence of blasphemy was aimed at attacks on a religion, not at attacks on the people who hold its beliefs. We all have to put up with having our deepest feelings injured from time to time, but we don't have to put up with having hatred stirred up against us. And the Law Commission pointed out that there already were offences of intentionally stirring up racial hatred, introduced by the Race Relations Act 1976. This could be extended if attacks on people holding particular religious beliefs became a substantial problem. And so it came to pass. The Racial and Religious Hatred Act 2006 created offences of intentionally stirring up religious hatred. It's much more defensible to protect the people than the belief, and it's much more defensible to protect them against hatred than against injury to their feelings. Although even this can be regarded by bodies such as Index on Censorship as an unwarranted interference with freedom of speech, especially if the concept of hatred and stirring up are given an elastic interpretation. So we must continue in the law to be vigilant in the protection of freedom of speech. Be that as it may, the introduction of these offences meant that the blasphemy offences were no longer needed, and they were abolished in 2008. So that is rather a long time after our report, nearly 25 years. Professor Farrand and I attended a bye-bye blasphemy party arranged by the National Secular Society, at which the offending poem was read by Sir Ian McKellen, no less, which is why I know it's not a very good poem. Never say never in law reform.